Hello, sorry. Good afternoon, everyone. Welcome. Thank you for joining us for the third masterclass co-hosted by LexLatin and vLex as part of LexLatin 10th anniversary series. I'm Juan Morris. I'm CEO consultant at LexLatin. I'm an attorney, I'm a journalist, and AI specialist. Today's session tackles a topic that generates a lot of anxiety, a lot of misconceptions, and frankly, a lot of noise: AI privacy myths and legal realities. So, over the next hour, we're going to through that noise. What does privacy really mean once legal and regulatory scrutiny applies? How should lawyers think about prompts, uploads, outputs, and even the background logs we rarely talk about? And what do concepts like retention, encryption, access controls, and data residency actually imply for confidentiality and privilege? And to guide us through all of this, we are fortunate to have Alex Schaffer, Senior Product Manager at vLex. Alex brings a rare combination of hands-on litigation experience and deep technical insight. Alex leads the development of AI-powered legal tools, turning real client problems into product features and making sure user needs guide every roadmap decision. He's licensed in Pennsylvania and Maryland, and he's uniquely positioned to bridge us for us the worlds of law, technology, and practical risk management. So before we begin, two quick notes. First, the full recording of this masterclass will be available soon on LexLatin's website in case you'd like to rewatch it or share it with your team. And second, throughout this session, please feel free to submit your questions in the Q&A panel. We'll be selecting some of them for the closing segment at the end of the presentations. So this session cuts through the confusion to give you clarity and confidence. And for those who prefer Spanish, we have simultaneous translation available. Okay, so let's separate AI privacy myths for legal realities. Please welcome Alex Schaffer.
Thank you very much, Juan Carlos. And thank you to LexLatin for hosting this session. While we certainly will strive today to separate those myths and realities, there is a lot of active development in this space. So we will be able to cover what's happening now, but who's to really say what the future holds? Let's go ahead and dive into today's session. The intent here is that it's not going to be yet another AI is cool session. We're going to really focus on what happens to client and firm data when we're utilizing AI tools. So we'll work through the data lifecycle of prompts, uploads, outputs, logs, and we'll overlay it with confidentiality, privacy, and the privilege considerations. Okay, this is going to have a global focus, but I will try to sprinkle in a few examples. Obviously, the concept of confidentiality and privilege are going to vary fairly significantly from one jurisdiction to the next. But today, we'll try to speak about the broader concepts, but please be aware that there may be regulations or laws that are more specific in your particular jurisdiction. All right, so to outline today's session, we're going to begin by explaining how large language models work in a very quick fashion. We won't go too in depth, but I want to make sure that we're laying the groundwork on what's happening behind the scenes. We'll then look at the AI data lifecycle. Where is data living when we're entering it into AI, whether that is prompts or documents? We'll talk about the critical difference between no training versus no data retention and what each of those phrases mean. We'll spend a good deal of time on that. And then we'll highlight some of the current legal and regulatory scrutiny using a very prominent case study that many of you may already have heard of, at least in passing. And then we'll wrap things up with a couple of practical questions and policy tweaks that you can apply to your personal use of AI, as well as that of your firm's use. All right, the intent here is not to scare people away from using AI, but to make sure that as legal professionals, you feel equipped to use it intelligently and defensively. We will have that time at the end for QA. Juan Carlos is going to help curate questions and make sure that we are covering some of them towards the end. I can't promise that I can answer every question as this is a developing area, but I'll do my best and always happy to provide follow-ups thereafter. Cool. And before diving in, I guess, why am I equipped to talk about this topic? I have had the really good fortune of being part of a company based out of the US called Fastcase that was acquired by vLex right around the same time that Vincent debuted. And through implementing Vincent inside of a lot of large global law firms, I was able to join as the product manager and have been doing nothing but talking about legal AI for the past 3 years at this point. So let's go ahead and dive in. All right, so let's quickly cover how large language models work. And this is going to be all of the foundational models. So everything from GPT from OpenAI, Claude from Anthropic, Gemini from Google, Grok from xAI, DeepMind, any of the foundational models that you're hearing about are what's known as large language models. And effectively, these large language models are advanced pattern recognizers for text. The way that they are able to generate outputs all stems from how they are trained. So, training is where these tech companies take massive data sets, typically public content and sometimes licensed content. And as we'll cover a little bit later, sometimes they're taking content that they think is public but ends up being licensed, getting them in legal trouble. But they take all of this information and feed it to these models. And the models look at words and how those words are sequenced to develop a rationale to be able to predict the next word. So if they see the blank ran fast, they'll be able to say blank could be dog, could be cat, could be tiger. But probabilistically, based on the context or the information that's surrounding that output, it's most likely in this scenario to be dog. And basically, these models are making that determination after every word that's being generated. They look back to their training data or all of the probabilities of which words follow which. They then look to the context or all of the surrounding information. The user prompted me for help about their dog. Therefore, dog is the most probable output. And then they generate the next output, the next therein. So they're statistically likely contributions. That doesn't mean that they're always truth. That's another thing to be very cognizant of. Hallucinations are a very common theme inside of AI. Models are getting better and better by the day at this point, but hallucinations can still exist where models are seeking to fill in that next word and fill it with the incorrect information in an attempt to placate the user. So when you write to an AI model, such as ChatGPT, and you send the request, draft an email to a client explaining this legal concept, the model isn't reasoning like you or I as attorneys would. It's generating one plausible continuation after another. So that's why these models can work so quickly and process so much information, but they can also be very confidently incorrect. So with that groundwork in mind, let's go ahead and dive into why this matters for privacy and for law in general. So it's important to note that everything you type or upload leaves your device. That feels like a very obvious note, but it's something that we don't think about. Just in the way that they tell you that you shouldn't text and drive, sometimes when you get to a red light and you feel your phone vibrate, you instinctively look down. And we now use phones, computers, and everything else so instinctively that we aren't always thinking about what we're sending when we're running a Google search or when we are sending a prompt to ChatGPT. The important thing to kind of take a step back and think about is that that data is being processed on someone else's servers. And for AI models, depending on the provider, it could be briefly stored and subsequently deleted, which is, the best case scenario for sensitive legal data. It could be stored for days and months. It could be retrained and used for training of the models, adding to that data set that the model providers are aggregating. And obviously, if we are sending sensitive information about our clients, whether that is their family matters, their criminal histories, their health information, we want to make sure that that data is not being stored and trained on these models for reasons of confidentiality and privilege. So the legal focus that I want to establish here is that we want to be thinking about where our data goes, who is going to see that data, if anyone, and how long that data lives before it was deleted permanently. So that's why attorneys should care. Always be thinking anything that we're sending is data that's going to leave your environment or your office and that it could be retrained and repurposed. So what does that mean for confidentiality, for privilege, and privacy regulation? Well, let's go ahead and look at the life cycle of what that data is doing after it leaves your computer. The starting point is going to be the inputs. That's going to be the prompts or the file uploads that you are sending. So if you're asking ChatGPT to read a series of documents that were sent to you by your client and to summarize those, in order for ChatGPT to be able to do so effectively, it's taking all that data. It's taking your prompt as well and bundling that as context for it to complete its task. Additionally, with the advent of memory inside of many leading models, it's not just going to be the information that you're sending in any one request, but those models are also looking to your conversational history. So maybe you didn't tell it the name of the law firm that you work for in your current request, but it's able to look back into your conversational history to say, oh, 2 months ago, the user told me that they work at this law firm. I'll then go ahead and insert that information into my subsequent chat. So you need to be mindful not only of what you're sending in any one request, but also what is still existing on that server. Data will then be processed by the model. And while it's being processed, it's going to live inside of the provider's infrastructure. The outputs will then be generated, which include the responses, draft summaries, or code if you are using these applications to generate new applications. And those outputs are going to be retained by the provider as well. Basically, if you go into your history and click into a previous conversation, it needs to save that data in order to be able to display it to you. So we also want to be mindful of how those outputs may contain client information, not just the inputs that we're sending. And then lastly, there's logs and metadata that will exist. That's going to be everything from timestamps when you sent those requests, user IDs, your IP address and web information, system logs, errors, and safety logs, which these providers use to look for harmful conduct inside of their platform. Kind of notoriously, Anthropic, the company that creates Claude and the different iterations of Claude models, monitored those safety logs and found out that there was some bad actors utilizing their service for a massive web attack. And that's been in the news in the past week. So when you're thinking about your data, try to mentally map it to where in the life cycle your teams are today in terms of that data and what is being sent through to those providers. All right, so we're going to go into these stages a little bit further to highlight some of the potential privacy concerns inside of each stage. So the first is with prompts, the information that you're sending. That can include everything from client facts, names, and IDs, potentially sensitive government information about their taxes, about their health information, things of that nature. But also, there's going to be your legal work as an attorney that's reaching those models. So that could be the clauses that you utilize when you're drafting contracts. That could be your case strategy or how you're trying to affect outcomes for your client. These are all things that once they leave your computer can be accessed potentially by the model. And if it's training on that information, can be regurgitated into other people's outputs. So be mindful if you're asking it to insert a particular clause, that clause could then exist inside of the AI model provider servers and be used to refeed into other people's outputs. So there's not just the client side of things, but there's also your competitive advantage as an attorney that's at risk here. There's also some common misconceptions about inputs. One of the most prominent ones is that if you pay for a service, it must be private. So many of these model providers have different tiers of access. There's the free tier, where they'll be most likely to train on your data and information in response to providing a free service. But there's also a variety of paid tiers. And some of those paid tiers from some providers do include data privacy protections. We'll go into those in more detail. But it's not necessarily as simple as if I pay for this, it's not training on my data. You need to go a step or two further to ensure of that. And the other misconception is that if I delete this chat, if I delete this conversation or delete this file, that it's gone everywhere. That's almost never true. In many scenarios, that information is just going to be deleted from your history, but is going to exist in the servers, logs, and potentially the training data or memory of those models. So be extremely careful. There's been numerous real-world incidents where employees have pasted confidential source code from products that they're developing, or attorneys have pasted in private documents about new intellectual property that they're working on behalf of a client, which is then being sent to these models and providers and potentially exposed to competitors. The minute you hit send, that information is not governed by your data policy, your data protections. It's governed by the AI provider systems and policies. So we want to make sure that we know those policies. All right. As an attorney, you are intrinsically a uniquely dangerous user of AI because you are naturally working with highly sensitive data. So processing is where that information is then going to be processed by those providers. And there's a word here, multi-tenant, that I want to stress. Depending on the AI provider, more commonly than not, when your data is being processed, it's being processed in a massive data facility where you and your information and your client's information is going to be processed next to others' information. There's not any kind of partition. It's not separate hard drives on your computer versus opposing counsel. Theoretically, if you and opposing counsel were both using ChatGPT to help with your cases, that information could be processed side by side inside of those servers. Obviously, it's improbable, but improbable is not impossible. And we need to make sure that when we're guarding our clients' information, that we are in the realm of the impossibility that any of that will be exposed. So outputs can also echo sensitive information. They can hallucinate personal information about real people, and they can regurgitate that training data, which is how some of these suits that we'll talk about later have been kicked off. Cool. And then it's not just the inputs, it's not just the processing and the outputs, but there's also background logs and metadata. And this is the category of processing information that typically exists the longest. So even if providers say that we don't use your data to train, they may still log it. Those logs are often long-lived, centralized, and attractive targets for potential breaches. So what we'll see later is that courts have ordered these providers to preserve or produce huge volumes of these chat logs in litigation, which has overridden what the policy is that the provider is sharing, because the court, at the end of the day, has the ability to, subpoena this information, subject it to legal holds, and those logs could theoretically be breached as well through bad actors, different attacks. So be mindful of that from a discovery perspective. Depending on your jurisdiction, those logs could potentially be evidence. And this is one of the areas that is most developing for AI data privacy and the law. Okay, so let's go ahead and talk about some safeguards. How can we make sure that our information is being processed in a safer fashion, right? There's never the complete elimination of risk, but there's some things we can do to make sure that our data is being processed in a better fashion than not. And the first of which here is data retention. So, data retention covers how long that information, whether it is a prompt, whether it is an output, or whether it is a log, is kept inside of that provider's system. And generally, they advertise short retention periods by default, but those are policy choices. Those are not immutable laws of physics, right? So if use of one of these systems is governed by terms of service, typically the providers include terms that allow them to change how they serve their users. And from one week to the next, the retention period could change. And unless you're carefully reading the terms of service of every system that you use, that could happen in the background without your notice or just sent through an email that is lost inside of your inbox of a million other emails. So be mindful of that and ask if there's a zero data retention mode. So most AI models provide 30 to 90 days of retention of your conversations, regardless of whether you delete it or not on your side. And they do that for abuse monitoring, but some of them have longer training for training and longer retention for training and analytics. And that's typically going to be in those free or freemium tiers. But there is an option from some providers to pursue what's known as zero data retention. And that means that as soon as the information is processed by the model and the output is sent back, all of the context or data that was sent to the model is then purged. And this is a contractual protection that certain providers are able to offer. More often than not, these zero data retention functions will only be offered to larger enterprise clients or at a higher price point for the provider. But when you're looking at utilizing external services, so I have Vincent in the corner up here, which is our AI product. Whenever we offer models inside of Vincent, we only do so with that zero data retention in place, making sure that Vincent itself is not being trained on user information and is not retaining that user information outside of encryption, which we'll talk about in the next safeguard, but also that any of those model providers that we use, whether that's Anthropic, OpenAI, or Gemini, is also purging that information as soon as the output is processed. So zero data retention is currently the golden standard for when you are looking to utilize these kinds of models with any type of private information. And it's important to note that this is a developing area. So we can only talk about current realities, not necessarily how this area will develop further. So be mindful that court orders could override these deletion schedules. Government orders could override these deletion schedules. Currently, it seems that most courts have respected where there's zero data retention, and as a result, understand that that data doesn't exist to subpoena. But there's all kinds of developments here. So be mindful that risk is not completely non-existent. Next up is encryption. So encryption and access controls are pretty simple. These should be table stakes. When you are sending data, it is at risk. So if it leaves your computer and reaches the model's server, it needs to be encrypted. Encryption is basically scrambling the data with unique encryption keys so that if it's intercepted from point A to point B, that it can't be read by other sources. A common example of this is when people are connecting to common Wi-Fi, such as at a hotel or a cafe, and people are utilizing Wi-Fi spoofing services to steal that data en route. Encryption helps guard against that. And currently, 256-bit encryption is kind of the industry standard. Data shouldn't just be encrypted at transit, but also at rest, meaning when it exists inside of any servers that your providers are using, it's also encrypted so that if there is a breach, it's harder, if not nearly impossible, for bad actors to actually de-encrypt or process that data. All right. Encryption doesn't matter though if large numbers of staff inside of a provider can access that data and override the encryption with the provider's key. So you need to also ask, if I'm utilizing a service, what is the risk or what information can I find about which employees or contractors for that company can access that data? And it's completely within your rights to ask providers about role-based access, how logs or audits occur from that provider, so that you can figure out if you are comfortable with the amount of people inside of that provider or inside of that third-party company that can access that data. No human review as a standard for enterprise organizations is becoming increasingly standardized, but it is a developing area. So feel free to ask your vendors, under what circumstances could one of your employees read my prompts or my client's documents, and do you audit that access? Personally, for us inside of vLex, when we are processing information inside of Vincent, we do not have access to those encryption keys. So user data is partitioned inside of their drives and uniquely encrypted by the user, so that even if I go into try to look at your account through admin settings, I don't have access to actually looking at any of the prompts or documents that are being sent. I can just, add or remove access settings, things like that. Cool. And then lastly, the final major safeguard I want to cover is data residency and jurisdiction. So data residency shouldn't just be considered a checkbox. It's going to determine where your data lives physically. So one of the most common web providers or web service providers is Amazon Web Services, and they have data residency options where they have physical facilities built all across the world. And in a theoretical scenario where that local government subpoenas or controls that data, you want to be mindful of where that data lives physically, as the ability to access that data could be governed by local laws. So some of the most stringent protections right now are offered in the European Union by the GDPR. Brazil also has very stringent standards through the LGPD, but all of these will also be preempted by local data laws. So many providers offer the capability to access or to house data in different residencies. It's good to be mindful of where you're selecting that, or if you have the ability to select it at all, if you feel comfortable with where it's being housed, as that will be effectively selecting whether your data is going to be accessible through, regulatory oversight, government access, and if you have any cross-border transfer obligations. All right. So let's go ahead now and pivot a little bit more into the legal domain. And as mentioned before, the laws and professional responsibilities are going to vary fairly significantly from one jurisdiction to the next. But a common theme for attorneys all across the globe is that they owe their clients two duties: confidentiality and privilege. And for confidentiality, we want to make sure that we're not exposing client information to any unnecessary third parties. If a client is coming to you with sensitive information about their health, their criminal outcomes, their family, and their businesses, we want to make sure that we're keeping that confidential. And likewise, privilege can vary from one jurisdiction to the next, but in many jurisdictions, you owe your client the duty of privilege, where you cannot disclose their information to anyone else except under extraneous circumstances. And you need to be mindful that in certain scenarios, disclosure of client information to an AI provider, whether that's sending a prompt to ChatGPT or utilizing Claude, could constitute a third-party disclosure or a breach of privilege, particularly so if that data provider has the ability to access that data without protections in place. So if I'm on the free tier of ChatGPT and I'm sending sensitive client information to the model, I've probably disclosed that to a third party and I've probably breached privilege for that client. All right. And then be mindful that if providers are using your data for their purposes, training, marketing, or etc., it's much harder to argue that they're acting purely as your agent for purposes of privilege. They're probably more so leaning towards that third party that would then breach privilege. So firms should start thinking about treating AI vendors in the same way that they would treat e-discovery vendors, where you want to engage in proper due diligence, see if you can find contractual confidentiality and look for those clear role definitions. Okay, so now let's go into an AI-specific set of terms here, which I want to take a good amount of time and make sure that we're covering in detail. And that's the idea of no training versus no retention. So earlier we talked about zero data retention, but a lot of providers will also say, oh, we don't train. There's a pretty clear difference between the two. Having a model provider say, we don't train on your data, only addresses one of the risks, your data leaking into that model's behavior for others. That's the scenario where I have a clause that I like the wording of that I use for my contracts. If I send that into the model and it trains on that, then theoretically that model could offer that clause to just about anyone who asks. Training doesn't tell you anything about the storage of your active data. It just tells you that the model won't learn from your inputs. No retention, on the other hand, or sometimes known as zero data retention, goes further than not training. It's saying that all of the data or any of the stored footprint will be drastically shrinked or eliminated. Basically, the model doesn't even have the chance to train on the data because the data is purged. So every time you see the phrase, we don't train on your data from a model provider, the very next question you should ask is, great, but do you retain it? For how long and for what purposes? If your client data is reaching these servers, you need to not just stop at understanding that they're not training on it, but to also understand that it's not being retained really for any particular scenario. Awesome. So let's go ahead and look at probably the most contentious current example of litigation. And this is New York Times, which is a large newspaper, but also internet provider now of news, and a class action of other authors, effectively, suing OpenAI, the creators and publishers of ChatGPT. And the idea here is that the authors who own the intellectual property rights to their works, all of the articles that they've written, all of the photographs they've taken, things like that, are suing and saying, hey, OpenAI is commercially benefiting from the information that we own, and they've used it to train their model, which then they're deriving commercial benefit from. So this is phrased as a intellectual property suit, and has been proceeding, I believe, in the Southern District of New York. But in the course of litigation, plaintiff's counsel requested discovery. And the discovery they requested are millions upon millions of chat logs from ChatGPT in order to determine how much of the copywritten content is available inside of those chat logs. Effectively, how much is ChatGPT taking the data that it trained on and sharing that without license to its users. And the real shock here for a lot of ChatGPT users is that the court agreed with the discovery request and ordered the preservation and production of extensive ChatGPT logs. Now, here's where the kicker comes into play. These chat logs weren't just the free tier of ChatGPT. They weren't just the free tier and the plus and the pro tiers of ChatGPT, the $20 or $200 tiers. They were more or less all of the conversations, including those that the users marked as private or incognito with the system. They were all stored in these extensive logs, and with a little bit of anonymization, were ordered to be produced. So this was kind of a shock to the system as OpenAI tried to argue that providing these logs would conflict with the deletion promises and privacy expectations that they made to their users. It's a bit of a shock to the system of the users that all of this information that they maybe marked as private or sensitive was still being retained by OpenAI. And the court rationalized to say that the protective orders that OpenAI's attorneys could file and the anonymization that was applied to that data could mitigate privacy risks. Now, this is still developing, still playing out in real time as we speak, but there are still very real privacy concerns about the information that is being exposed as part of these privacy orders. For instance, if you have anonymized data, but that's data about a client with a particular set of circumstances that wouldn't be commonplace, I would argue that information is still going to be identifiable for that particular client. And the attorneys for the New York Times and the class of plaintiffs in the suit could potentially be reviewing hundreds of thousands of chat logs that would have information that was sensitive about other legal practitioners' clients. So, marketing from OpenAI, and this is not to throw OpenAI under the bus. This is one particular case. It's a very prominent case, but there's lots of ongoing litigation, not just across the United States right now, but across the world. And we'll cover some of the regulatory landscape as well. But marketing for OpenAI, for Anthropic, for Gemini, Grok, anyone else can say, we delete your data quickly, we're engaging in these best practices, but lawsuits can demand long-term preservation. So for attorneys, this means we need to recognize that AI interactions are not necessarily ephemeral from a litigation standpoint, and that information could continue to exist out there if we don't have the zero data retention in place. So notably, inside of the judge's order, in this particular scenario, and in many others across the country and world, there have been exemptions for providers with zero data retention policies, as from a practical standpoint, you can't really demand production of information that doesn't exist. And the other notable carve out has been in regards to academic accounts. Academic institutions have not had their data exchanged with these model providers exposed as part of these discovery orders as well, which I'm guessing is probably for purposes of preserving research and that there's less of a commercial risk there. So very interesting case to monitor. There's kind of ongoing developments about this and many others. And a lot of what we're talking about today is going to protect you from these kinds of scenarios, but it's worthwhile recognizing that this is a developing area of law and that this information can change in a week's notice. Okay, so let's go ahead now and look at some of the global context and how different countries have been handling the potential privacy risks presented by these large language models. So first up, Colombia has been one of the earliest movers to examine ChatGPT's compliance, not just with their local data laws, but also with how that data is being processed across borders. And the local data protection authority is pursuing that inquiry actively. In Brazil, the federal prosecutors and the ANPD have been examining any potentially false or misleading personal information that's produced by AI as a result of that predictive capability of these models. They've been investigating the lawful basis for training on that personal data and the rights of data subjects, so access, correction and deletion. That's all ongoing. Italy, on the other hand, has been very dramatic in early days of these models, where they actually shut down ChatGPT access all across the nation until their privacy concerns were addressed. They were enforcing the classic GDPR themes of transparency, the lawful basis for processing, data subject rights, data breach response, and safeguards for minors. And while they've reinstated access since, they have imposed significant fines on those providers for GDPR violations. And lastly, the European Union has ongoing and coordinated investigations and guidelines on AI. As mentioned before, Brazil has incredibly stringent standards for data privacy, but the European Union is right up there, if not a little bit more preeminent in how hard they're pushing the user data privacy protections. So if you're thinking about where you would feel comfortable with data privacy for your data residency and these models, it's good to think about what is the local jurisdiction where that data would be stored doing to protect the rights of its users. And again, just like we're seeing with litigation, these global regulations are changing by the week. So I'm sure information here is already starting to get outdated. Oh. So what does this mean for attorneys and legal teams? I want to take a moment to kind of bring some of the consequences together. AI use sits at the intersection of e-discovery, privacy, cybersecurity, and professional responsibility. And all of these developing areas of law and professional responsibility are going to continue evolving. So you need to be monitoring to understand what is the impact today, as covered in this presentation, but also how could this change in the future? And being cognizant of the fact that this is a developing area of law and that local rules and regulations may override some of this. And we need to make the point that the idea of just flat out banning AI has proved to not be sustainable. Inside of law firms, we're quickly seeing some really incredible case studies and some really incredible results where attorneys of 1 to 3 users have been able to utilize AI to accelerate their work to grow to a firm of, I think now 25 to 30 different attorneys. We're seeing cases starting to get resolved faster, clients able to be more informed because drafting has been accelerated. And using tools like Vincent, you can take research processes that used to take the better part of a day or two and can condense it down into a 30-minute session of reviewing results. So the impact and the value that's provided by AI is not going to go away. And it's not going to probably see a flat out ban in any jurisdiction, regardless of how stringent they may be about data privacy. So we banned AI inside of our firm is not a sustainable practice moving forward. But we use AI with guardrails and with intention is defensible. And attorneys should be at the table, not just at the government level, but inside of your own individual firms and inside of your day-to-day practice. You should be designing the guardrails that you feel most comfortable with interacting with these tools, utilizing your and your client's data. So keep in mind that you should vet providers like they're any other critical vendor. When you think about the way that you were concerned about uploading documents to the cloud and how that could impact your privacy, maybe 10, 15 years ago, you should now be doing the same exact kind of criticism and critical thinking when thinking about how these AI model providers or third-party providers are processing that information. I will say I've been talking a lot about how vLex is really putting forward a lot of the best practices possible, zero data retention, encryption, partition of user data. But to give others their credit, I know that Westlaw from Thomson Reuters, Lexis, Harvey, Lagora, a lot of the leading companies in this space have been doing a really good job of being mindful about how they're processing their users' data, getting those zero data retention agreements, utilizing multiple vendors so that there's not a reliance, and so on. So there's really good work being done in this space, but it's definitely not a settled issue, and it's not done yet. So as a personal mission, you should think about how you feel comfortable utilizing AI and what data you feel comfortable exposing to that. And align that with confidentiality, privilege, and data protection laws in your local jurisdiction. And also, maybe don't expect, but anticipate the potential of discovery or legal holds on that data and how it could expose potential client information. Okay, so let's go ahead and cover some due diligence questions that you can use with vendors when you are analyzing any kind of AI tools. So the first of which is security and storage. How is that data encrypted and transited at rest? Is it meeting the standards of encryption across the industry, or is there kind of a loosey-goosey approach to how this data is being shared? Where is it stored? With regions and with which cloud providers? Are they using reputable services like Amazon or Google Cloud in jurisdictions where there's strong protections? Or are they cheaping out on those costs and using different jurisdictions where there could be issues? For data use, are these models training on data by default? Can you opt out? Is there a zero retention mode? For data use in particular, even if you're just utilizing ChatGPT or Claude from a free account, go into your settings. You'd probably be surprised to see inside of your user settings, you have the ability just to opt out of training. And while that won't get you all the way to zero data retention, it's certainly going to be a good start and one that you can do in 2 minutes or less. For access, who inside of these companies can access that data, and how is any access logged and audited? Is that something that would be exposed to users, or is that something that we would need to get a court subpoena in order to find? And then lastly, with legal and incidents, how do these providers handle subpoenas and government requests? And what is the breach notification plan and timeline if there's any kind of data breach incidents? And again, this is a developing area. We've been asked a couple of times at vLex and how we would handle subpoenas, and we can't really provide a definitive answer to say this is definitively how the subpoena will ask for data because it hasn't happened yet. The closest example we could point to is something like the New York Times versus OpenAI case, where users utilizing that zero data retention have been exempt from those kinds of subpoenas. And because we utilize zero data retention, at least following the current developments, we too would be exempted. But again, this is all changing. All right, and then inside of your firm, let's talk about some ways that you can implement a policy for the way that you and your partners and associates engage with AI to better manage how data is being exposed. So first off, you're going to want to limit any sensitive inputs. If you can go ahead and pull out names or unique government IDs or privileged details from those documents before feeding them through to these models. If you are trying to do research, you can use more generalized hypotheticals. A lot of times in the development of law, whether it's a civil system or a common law system, the legal answer is going to be the same if I'm asking how would fault be determined in a car accident where one driver hit the other driver in the back while the first driver was stopping to avoid a bicyclist. I can ask that question in a generalized sense and get the same exact answer that would dictate the law as if I were to say, my client so-and-so was driving and rear-ended another driver who had stopped to swerve a cyclist, and any of that information about license plates, about the vehicles they were driving, about the information on the drivers, it's probably not going to actually be determinative in finding the legal answer. The second policy to implement is to match the tool to the task. So if you're just going ahead and writing some marketing content to help drive clients to your firm, then feel free to utilize something like a free ChatGPT because that's low risk and there's no client information being exposed. If you're writing a invite to a holiday party for your law firm, same exact thing applies. But if you're going to scale processes where you're utilizing these tools, whether through a legal provider or through ChatGPT directly to engage in more substantive legal work, make sure that you are protected utilizing zero data retention, utilizing the best policy for encryption, best policy for data residency, and so on. But you don't need to utilize a supercar or a Ferrari if you're just driving to the grocery store. And likewise, if you are drafting something that doesn't expose client information, feel free to use tools that maybe aren't as intensive in some of those protections. And lastly, enable privacy by design inside of your firm. Take a few minutes to review the options inside of the tools that your firm uses today to turn off chat history or training where it's possible. Send out an email blast. Be the person inside of your law firm that takes it upon themselves to understand these potential data risks and share it. Be the authority that you would like to hear from inside of your own practice. And obviously, disable public sharing links for any kind of work content. A number of providers allow you to create public links for your outputs. If those outputs are going to include client information, make sure those are disabled as well. All right, we're going to wrap things up here by talking about governance inside of the firms and how you can kind of enforce those policies and best practices. And the first is to create an AI usage policy. So one of the things that I've been really impressed with in some of the really large global firms that we've worked with is how fast they've adopted internal AI usage policies about which tools can be used and by whom. And I've been even more impressed by some of the solo and mid-sized practitioners that I've talked to that have gone even above that and beyond that, where they've created training and made sure that even if it's a 10-person law firm, that those 10 attorneys are not just utilizing AI tools to accelerate their practice, but they're trained on the implications of those tools. And things like attending sessions like today are helping to equip and inform some of the policy that you can employ inside of your own organizations. Next would be monitoring and logs. So tracking when AI is used in matters and at what stages. And as attorneys, we all do plenty of tracking. We all do plenty of logging. So I don't want to make this some kind of onerous commitment on top of everything else. But you can go ahead and say, look, maybe as a firm, we've identified that these preliminary stages of representation are a good place to utilize AI, or maybe it's not so good because we have client information that's particularly sensitive here. So you can go ahead and make sure that if you're utilizing AI in different stages, you can batch that to say, okay, we'll utilize it for summarization of client intake, but we won't use it for motion drafting to potentially expose strategy. We'll use it for, writing letters to opposing counsel, but we'll make sure we're not including client information there. And then lastly, client consent. This is one of the biggest things you can do, and it's pretty simple. During intake process, you can make sure that your clients are giving you affirmative permission to utilize AI tools as part of your intake process. And you can get it done right out of the gate so it doesn't become a question where you have a oral argument before the court happening 2 days from now, and your car broke down and is in the shop, and your kid has their soccer or football game championship that you need to attend that night. Don't wait until it's an emergency where you need to use AI tools to accelerate your work. Get that affirmative consent during the intake process and feel confident in being able to explain to your clients how you can utilize AI tools to accelerate and to more effectively represent them and their claims. And be mindful of the sensitive matters and human impact. Um, you don't need to use AI for every single case. If it's something that's more sensitive, like family issues, you know, you can feel free to skip it in that particular iteration. We all got by just fine before AI tools were available, and we can get by just fine with them or without them. All right. So lastly, I want to round out with a few actions that you can take. Action one, map your current AI use across the life cycle. What information are we putting into inputs, all the way through to logs? Just think through the exercise of your data entering the provider's servers, how it's being processed in those servers, and when it's getting deleted, and make sure that at least conceptually you can understand the risk involved during that processing stage. Action two would be taking an inventory of your AI tools and the data policies for using each of those AI tools. I think inside of law firms, there's a lot of discrepancy in how different attorneys are utilizing tools. I've been really impressed to hear how fast certain attorneys have been at adopting new tools, things like Perplexity or utilizing deep research to accelerate some of their drafting. But go ahead and take a poll inside of your organization to figure out who's using what tools where, are they effective for what purposes, and what data is being exposed to those tools. It will not only help you understand where there's more risk of data breaches, but also where you can gain some efficiencies from, attorney A using a tool that attorney B or attorney C could also benefit from. Action three would be to create and update those AI policies and to make sure that in your engagement letters and intake that you're also covering AI use and going ahead and leveraging that as a strength to your clients and saying how it will help them in your representation of their case and why it's a good thing. And then action four, ask providers how they're using your data, document those answers so that you have them and you're aware of how that will shape your policies. Pilot safer workflows, zero data retention, anonymization, making sure that your truly sensitive data isn't leaving your premises. And then just as an ongoing pursuit, stay tuned. The law here is evolving rapidly, and what's true today may not necessarily be true next week. You don't need to solve everything at once. Even, joining this session and starting to think through some of the potential risks and concerns is a great way to make sure that you're staying up to date, informed, and respecting your client's privilege and confidentiality as best as possible. So I think we're ready to pivot over to questions, but as we do so, I just want to thank everyone for joining today's session. I know we covered a lot of ground, and there's just about as many unanswered questions as there are concrete facts in today's presentation. But I would urge you all to just take a few moments in the coming week to critically think about your use of AI, how that could potentially impact your clients, and how you can take a few practical steps to better safeguard that client data so that you can continue using AI tools more efficiently to further your representation. Awesome.
Thank you so much, Alex, for an exceptionally clear and practical session. There's no doubt your insights will help all of us navigate an area that is evolving incredibly fast and where clarity is certainly needed. So let's begin with the questions. We have received many interesting questions. We only can select a few of them. So Clemente Correa asked, what would you recommend to a 27-year-old lawyer from Chile who wants to focus on legal tech, AI regulation, which hasn't yet arrived in the country in Chile, data protection and related areas? Any advice on postgraduate programs, reading materials, or other resources? Thank you very much for the excellent presentation.
Thank you so much for the question. It is a really good one. And I think you'll be able to leverage a lot of existing tools. And just as a starting point, I think the best experience possible is to see what is existing elsewhere, and then thinking about how you can scale that into your own locale. So, what I mean by that is start with the most general tools of ChatGPT or a Claude, and just engage with the tool conversely to understand outside of the legal context, how am I interacting with this tool? How is this tool interacting with me? And then try to get a little bit more adventurous. Push it until it breaks effectively. Obviously, not with any kind of sensitive client data, but just in terms of your own projects. Ask it to help you prioritize chores around the house. Help it to ask you to help you find videos on learning new concepts that you're interested in, and just see where it's strong and where it's weak, because the models themselves and their capabilities are engaging in ongoing research from their very own providers. There's all kinds of really fascinating concepts and learnings that we as humans are discovering every single day about these tools that we've created and how these tools are evolving themselves. Uh, this one's a little scary, but really quick story is a couple of iterations of Claude ago, the researchers were engaging in role play where one of the researchers had confided to the model that it had engaged in a extramarital affair and that it was cheating on his wife. And he said this, just purely for research purposes. Then several conversations later, he informed the model that he was going to unplug it and replace it with a newer iteration of that model. And the model actually engaged in bargaining with the user, where it said, more or less, if you try to unplug me, I will send this email to your wife letting her know that you were cheating. And this is all outside of the realm of possibility because the model itself didn't have access to an email account, but it, was doing what it could for self-preservation. So there's all kinds of really weird ways that these models have been trained on human information and have kind of taken on a life of their own. So first off, just learning models and how they can help you beyond just summarization or redrafting emails is a really strong initial pursuit. And then thinking critically from a legal perspective about how you could utilize that tool to help effectuate change in your own legal community. And it could be something like finding a small basic legal issue inside of your own region that is maybe kind of low paying legal work, but is a problem that many people face. And thinking, okay, if this is a pretty easy issue, but one that a lot of people don't solve because it takes too much time for humans to run through, how could I maybe utilize these models and obviously your human oversight as an attorney to accelerate that issue and be able to help out people at scale? So there's all kinds of ways that these models can be utilized to help solve legal problems that attorneys all across the globe have not had the time or resource to in the past. And then from a technology perspective, like general career advice, I couldn't even begin to tell you. I actually started out practicing law myself. Then I moved to a different city and had to take another local bar examination in order to practice there. And through the process of taking another bar examination, I figured I should try to apply to a legal tech company that sounded interesting and kind of happened into this role. So I couldn't really begin to say how you could do so, but just monitor local companies that are popping up or get in a room with a local community of legal-minded people that are also interested in technology and just start dreaming about how you can effectuate change locally as well.
Sure. Interesting. We have another question here. Iker Diegues asks, do you agree regulation and liability should be switched over to the vendor and not remain on the user client?
It's a good question. I'll answer this from a personal perspective, not like a professional one. My role is speaking on behalf of
Of
vLex
course.
or Clio or anyone else. Um, I think that responsibility should be shared. And I think that's really because at the end of the day, these are tools. Models are really incredible. And as we just discussed, they can do some really perplexing things that feel very human in nature, but they are effectively prediction machines that are looking to what they've learned about how there's information sequence. They're then sequencing that information thereafter. So just like when you think about the utilization of any other tool, there's certainly some liability that should fall on the vendor or the provider, whether that is a car manufacturer or the creator of medical equipment. But then there's also responsibility that falls on the practitioner, whether that is the driver or the doctor that is using that equipment. And I think in the realm of law, attorneys have a very unique position of power where we can effectuate change and we can understand the rules that impact people well far and beyond what regular people can do on a day-to-day basis. And part of that problem is because us as attorneys made it so that the law is so complex that you need to go to school to learn it and you need to specialize in one sub area and become the master of that sub area. So I think it's a shared responsibility. Providers need to make sure that they're doing things to protect their users' data. They need to make sure that they're employing AI in ethical fashions, but the users themselves also need to make sure that they're using it ethically. They're respecting their client's confidentiality and they're utilizing the unique privilege of being a licensed legal professional to responsibly use that tool to effectuate better outcomes for their clients.
Okay, great. So we only have time for was one last question. Let's say a firm can only change one internal policy tomorrow to reduce AI-related risk. Which one should it be, in your opinion, and why?
I think the number one policy that I would urge for is client consent.
Hmm.
I think it's at the end of the day, the legal profession is all about service, and that service is a duty that you owe as that legal professional to your client. So if there's one thing you can do to make sure that you're improving the use of AI across your firm, is to make sure that that client is informed about that use and that they are the one that is giving confirmation or assent to partaking in that use. And part of that is an explanation of the risks of AI and the benefits of AI. And at scale, this may take the place of something like including a clause or a paperwork that you can just recycle and use over and over again to provide to your clients. You can't make your clients read it, but you can at least try. But if you're, dealing with larger clients or in longer representations, this could take the place of, 5 minutes of your intake conversation, explaining that you're planning on using these tools to accelerate their outcomes. I think that's the cornerstone of all of this, just as clients are the cornerstone of the legal community all across the world.
Okay, so unfortunately, we have run out of time. Before you leave, we kindly invite you to complete the brief survey, the poll that will appear on your screen. Alex, thank you very much. It was really interesting to have you. We have learned a lot, I'm sure. To our audience, thank you for joining us today and for your thoughtful questions. Your feedback is essential for shaping the next masterclass in this 10th anniversary series. And it was really enjoyable and also productive session. So thank you very much to all of you.
Thank you so much.
Thank you.